This is our 12th lecture in Principles of Company Law, and we'll be looking at unfair prejudice actions, which is a direct action by which a member may seek relief from usually another member. So we'll look at the nature of the action, which is a little bit difficult to grasp. It's essentially equitable. And once you've seen it, you'll find that in an unfair prejudice action, you'll have to pay special attention to the facts of the case in order to ascertain the presence of unfair prejudice. The action itself is different from a derivative action, and we do have a judicial decision that we'll be looking at on that question. The unfair prejudice rests in the nature of the shareholders' relationship to each other, the members' relationship to each other, and we'll look at that, as well as the possibility for an unfair prejudice in large and listed companies, which is something that often has not been seen as possible, but Hong Kong has decided it is possible. And then finally, the unfair prejudice in foreign companies. And this we will not focus especially on the foreignness, but we will pick that up again next week. So the reading for next week will be very light because we will be circling back on the same case involving the Young Key group of companies again. Okay, so the nature of this action essentially arises from the delegation of power which exists in the majority rule relationship within the company. So we're used to thinking about this with a director. We understand that directors are appointed by the company. Directors have fiduciary duties and duties of care to the company. However, in a majority rule situation, we essentially agree that the majority will be delegated power over the affairs of the company. And so at any given time on any given decision, there will be a majority of votes. That could be one member, it could be a group of members, that will have received delegated power also from the minority of members. And this is what we're looking at essentially as a restriction by the equitable considerations that are examined in the unfair prejudice action. So let's see if this graphic is useful for you. If not, don't worry. Essentially what I'm doing is giving you this red line, which allows you to think of the expression that we use in English, that crossed the line. That's something which crossed the line. We usually use that not when there is a clear violation of the law or rule, but when there is a violation of some unspoken agreement or some unspoken expectation, which we find to be objectionable. Not the expectation, but the crossing of the line. So we have requirements that are specified by the law, and then we also, these are fair, and then we also have other understandings which can be expressly agreed, such as the Articles of Association, or they can be established by a history of a certain kind of relationship among the members. And so when an act crosses from fair to unfair, because it crosses the line, which is that line essentially a limitation which has been created because of expectations of the members from their dealing with each other, whether an express understanding or whether implied understanding arising from dealing. The understanding which could arise from dealing is often found in family firms, in smaller companies where there are personal relationships, and those smaller companies are sometimes referred to as quasi-partnerships. We're still talking about a company limited by shares, but we're talking about a company limited by shares in which the members have established some sort of a relationship with each other, and this relationship should be respected, although not required by law. Okay, so this is what we're looking at. We're looking at when these acts, which are the yellow arrows, cross that red line and go into the area of unfairly prejudicial behavior. Let me give you a couple of examples which are not coming from unfair prejudice. I think they would constitute unfair prejudice, but they also constitute a breach of fiduciary duty, which is something that you find under U.S. law, German law, to a certain extent under Canadian law. So this is something that's not as clever as the judicial decision of unfair prejudice, which is highly flexible, but something that looks a little bit closer to what we expect from a director. So let's say we have a company. It has majority members, and it also has some outside members, minority members. It has a business which is the cash cow of the company. We saw this somewhat in the David Chen case, where we have Tyson Holdings and Tyson Foundation, and Tyson Foundation generates most of the cash of the company. Okay? And the inside members, who control 51% of the voting rights, are also on the board of the company. And so what they then do is to set up a company of which they own 100%, and then transfer cash cow to that company in receipt for a payment. Now, in the future, when cash cow generates profits, the insider members will no longer receive 51% of those profits, but they will receive 100% of those profits because they own 100% of this company. The sale of cash cow may qualify as profit that then can be distributed 51% to these members as well. So after that one-time distribution of the sale of cash cow, then the minority members would no longer receive payment. Right? And when A Limited is wound up because it is not profitable, the investment of the minority members could be substantially lost or substantially damaged, but the insider majority members will go along with the same business activity, which is the cash cow, but it will be in a different company. So this would be the kind of thing which is legal, but unfair. And as I said, this under U.S. law would be a straight out breach of fiduciary duty, also because it goes clearly to the economic return from the company. Unfair prejudice is not limited to economic return. Let's look at another example. So here we have a group. Let's say this is our Cy, Max, and Eddie at the beginning of the development of their MOM device. They set up their startup, SME Limited, and they seek out the help of a VC firm. We talked about angel investor as a sort of a VC investor. The VC firm takes 60% of control, and the startup entrepreneurs have 40%. Now, the dream and the mission and the purpose of this company can be enhanced by merging with another company, which is represented by the triangle at the bottom of the page. And this is what the minority entrepreneur members would like to do. However, the VC firm has an investment in another firm. And for the VC firm, it would be advantageous to bring the startup into a relationship with the other firm that it owns. And so it uses its voting power, perhaps to bring in a relationship which is at a lower price. Or it could be at the same price, but not have the same overall long-term potential that the entrepreneurs who founded the startup want to see realized. And so the VC firm could cause the relationship to take place with its own subsidiary or its own held firm, but is this fair to the understanding which was established between the VC firm and the startup entrepreneurs? Right? So this is the kind of thing that we might be able to treat in an unfair prejudice action. And if we're talking about economic return from the two contracts, as I have here in the example, it would also fall into something like German or US law of the fiduciary duty of the majority shareholder. But that is not what we're looking at here in Hong Kong. We are looking at unfair prejudice.